So as everyone else, I'm absolutely delighted to be here, and have already found this morning incredibly stimulating, and Anya's presentation just now. So I'm going to be talking particularly about the project that went into this book, and Oxford University Press do this hilarious thing where they give you discount flyers even before the book is out. I presented this book before it came out in the autumn to a group of practicing lawyers, and for them, I think suddenly it just totally devalued the whole project, because they suddenly were associating, they were saying to me, I mean, it's discounted, kind of remaindered before it's even out. As soon as they said that, I thought, oh yeah. But anyway, I think however means is that Oxford University Press charges an awful lot of money. I think that's what it truly means. But there we are. So if anyone wants to take a discount flyer, no expectation at all, I'm just going to leave them there. Right. So I'm going to try to talk for around half an hour-ish. Of course, once I start talking about this book, I find it extremely difficult to stop. So anyway, I might still be in here in 3 hours' time talking to myself, but there we are. Let's hope not. I am going to focus on the qualitative analysis of judgments, but as I approached it in the book. But so that means explaining kind of how I got there, because it's one part of the methodology, so it kind of doesn't make sense unless I say a little bit about other parts. I have to say, and I'm looking at it through the lens that the organisers suggested. I have, interestingly, found it really quite challenging to do this, because this is, in a way, it's clearly not a book that uses feminist theorising, or that is specifically focused on the experience of women and gender and law. All of that is deeply relevant to what the book is about, because it's very much about egalitarianism, but I didn't approach neither my theoretical lens nor my specific focus was women as a group. But of course, for me, everything I do, in some ways, I know that a feminist sensibility is there. Everything I experience, everything I do, certainly everything that I write. So it's not wholly absent in that I chose the book and wrote the book subject to those, and chose the method subject to those influences. And what I do hope is that the methodological approach and the findings have relevance for studies that are taking a feminist theoretical position, and that find different ways of investigating the role of gender in law and society. So I am going to try to make it so that we have time for discussion, because I would really appreciate that interchange, because I think there is clearly very much a conversation to be had here. Okay, so I've given you a little handout, and I'm not going to go in detail through everything, but it does give people something maybe to come back to, or to look at, or to see things that I've emphasised. Okay, so what is the real life problem that I started with? And that says a lot about why I ended up with a more general egalitarian concern. It also says a lot about the the theorizing of the methodology that I ended up. So the problem dictated a lot of how I ended up tackling it. And essentially, it's straightforwardly this very peculiar thing that we are all living, and as lawyers, and certainly any lawyer anywhere near the area of labour and equality law knows, of an explosion in individual rights, individual labour and equality rights, and in my example particularly obviously related to work, so because some equality rights also apply elsewhere, but this absolute explosion, and it started slowly in the post-war period, but even in the 60s, and if we catapulted back to 50 odd years ago, we would have possibly zero individual labour rights. They were a very peculiar beast. 50, 60 years later, at least the most favoured legally have huge numbers of individual labour and equality rights, and that burgeoning, the exponential increase, particularly from the 90s onwards. A lot of people all say it's all EU inspired. It really is not. That's an incorrect characterisation. Quite a lot of it is homegrown. There's an EU influence, but definitely the UK ran with it. And interestingly, it goes across governments in the very recent era. So it doesn't matter if it's Labour or coalition. Yes, once you get into detail, but this broad framing of increase in individual rights, absolutely. But what it is not associated with, as we are also living, is a decline in inequality of all sorts, types, kinds, and of very serious depth. So individual rights have increased at exactly the same time as inequality and inegalitarianism and the experience of exclusion and disadvantage and oppression for all sorts of people, including very much related to their group and class identity, is absolutely also rising and has been a long-term trend, rising for a very long time within countries and of course internationally and cross-nationally. So that's the problematic. You know, we've got all this law stuff, which on the tin is about is emancipatory, is about improving the lives of working people and those with any kind of attachment to the labour market, but is not having that impact, not having the impact. So I found it very interesting this morning, the kind of conversation about feminism and an association with empiricism, and it did make me think, I'm absolutely sure that's one of the kind of subterranean feminist influences that was on me in both seeing the problem the way I saw it and then in the way that I ended up developing the methodology. And it's quite hard for me to work out. I've put in the empirical context, a little bit about the empirical context at the beginning and the legal context, but one could as easily talk about them in the context of the methodology, because of course it is a freaky thing to many lawyers, not to us, but to very many lawyers and to much of the legal academy, to think that the first thing you have to do with A is to identify a real world problem, B to find out anything you possibly can find out about it. And in a sense that's the first bit of my methodology, was to spend a very, very long time crunching through all sorts of sources of quantitative and qualitative data about the particular case study which I chose, which is the experience of conflicts about behaviour at work. And it involves crunching through a lot of stuff from organisational psychologists, quite a lot from sociologists of work, and really amazing socio-legal data which we have, particularly in this country, and which Hazel Genn absolutely was a pioneer of, but which, until I did this project, I've never read about it in relation to a labour inequality problem, because we talk endlessly about individual rights and critique them and, you know, lots and lots and lots about them, but we don't go and get the data which actually is there about the experience of problems at work, what people do about them, and what the outcomes they tend to achieve are. So that's a classic example of the sort of, you know, the acceptance, even in a subject like labour inequality law, of an internal methodology as being kind of not even a methodology, just a way of being, and not noticing, even when people feel they're being contextual, not looking out to what other things, data there might be, and things that they might need to know in order to give the best possible answer on existing tools. Okay, so this data, which is, and an interesting thing about it is there's the Genn research which has now been repeated again and again and again. So the data set is getting stronger and stronger, but there's all sorts of other stuff, the government doing all sorts of stuff of a similar kind about problems at work, and then qualitative studies, and it does start to paint a really very plausible and clear picture, and you know, it's always nice when findings are repeated by a lot of people, because you start to think, okay, they truly are onto something. And this is a picture of individuals trying to use this stuff. So the idea of individuals being totally disaffected and kind of not involved and hopeless and just, you know, letting themselves be oppressed, and not kind of active enough. So actually that rings true with the point made earlier about student disaffection, that we ought to be questioning about that. Indeed, rather individuals facing problems at work, non-trivial, substantial, trying to do something in vast numbers, 80-odd%, and then the depressing thing is very, very many. I think the data repeatedly has suggested over half just getting nowhere, not achieving anything. Of course, a tiny proportion who litigate, and yet when you read the papers and you listen to public discourse and discussion, that's who we'll hear about. That's where so much of public policy is about the 2 or 3%, the tiny number who go forward, and indeed a tiny number that is no doubt falling. And then this incredibly partial knowledge, however, despite some really good, particularly qualitative stuff, about the litigation system and how it works out for the tiny proportion who go ahead. One of the weird things is there's quite a lot about the employment tribunal system, but there's a vast amount of labour inequality legislation in the ordinary courts. I've never read an empirical study about litigation which notices that labour inequality are also litigated in the ordinary courts. And so that's interesting. Policymakers seem not to know it. Lawyers, of course, often are not involved in these studies, so you get these weird, that's just a system error, but in a way it's a sign of our discipline not being involved in this stuff. And then organisational psychologists and sociologists having quite a lot, including someone from Cardiff, fantastic study with a group by Ralph Fevre, who some of you may know, your colleague, about the experience of trouble at work. This group did this wonderful work, so we have quite a lot of deep knowledge about the experience of behavioural problems at work, although interestingly that sort of work often is largely, if not wholly, uninterested in law, and where it touches on it, no doubt influenced by the data that ignores ordinary courts, it often just gets it completely garbled and mangled. So again, an absence of lawyers involved, and the mistakes are not dramatic, because the important point in a way is that the law is just absent from that kind of research stream. Okay, so in empirical context, I have a lot of problems at work, a lot of people trying to do something about it, them using this acquis, this set of individual labour and equality rights, and scary numbers, getting nowhere, not knowing much about the litigation system, where we know something, we know that the individuals who go forward have a basically hideous time, but then also a lot about the depth of these kinds of problems. So you put it all together, you get a lot of problems unsolved despite this whole bunch of rights. And so the big picture is in the exponential increase in individual rights over a long run. The more recent other side of that story, although also going through Labour, Coalition, Conservative, is you increase the availability of individual rights and you deliberately, openly, straightforwardly bring in policy options to ensure they can't be enforced. And you're completely open about it. People are totally chilled about this, because of course we have a massive problem of people litigating. That's where they're talking about the 2 or 3%, a lot of whom are having a hideous time. And yeah, so that framing where you ignore the you ignore the iceberg of unsolved problems, and you focus the thing under the water of unsolved problems, and you focus. It's a bad analogy because it's much smaller, this tiny amount where it's actually litigated, and you reframe your policy all around that to ensure people can't litigate. Pretty much, it makes sense if you've got a distorted picture, then amped up by the media. Okay, so this is the context, the background. In a way, that's the first part of the methodology, to map that stuff and bring it together and show how it interrelates. On the second page of my handout, I've touched on I needed a starting point for the theorization of law and inegalitarian outcomes, and I needed a starting point that could cope with the fact that on the face of it, these instruments are motherhood and apple pie. They're about making the world a better place. They're the lovely bit of law. They're the bit where we can all say, yay, your law isn't all bad. It's trying to do something emancipatory, something about disrupting and altering the status quo, something about achieving an egalitarian vision. And so this is where Thompson's Whigs and Hunters from 1975, it's a long time ago, has helped me and gave me the theoretical perception. I'd be very interested to hear from others with more knowledge, more reading than me, whether they think I could have got it from a different and feminist source. I fully suspect that I could have, but that was the one that spoke to me. And it's the idea that he explored it in relation to Black Acts, totally different context, hundreds of years ago, Black Act rather, of a piece of legislation which was overtly repressive, and what he found, this painstaking historical study, that this deeply repressive legislation was undercut by the legal system, but in the opposite direction. Brakes were put on it, on this authoritarian use of power through law. So he ends up with this idea that, which I've included one of the key quotes at the top, which do go away and look at, the idea that in the same moment, rhetoric and rules of a society may modify in profound ways the behaviour of the powerful and mystify the powerless. They may disguise the true realities of power, but at the same time they may curb that power and check its intrusion. So this idea that law in its nature may always be doing two things at the same time, undercutting the status quo, restraining power, limiting power, but in the service, in a sense, of ultimately ensuring the status quo and the power relations remain perhaps entrenched, enhanced, certainly not deeply altered. And Crenshaw, her classic article about anti-discrimination, or in a different way, takes a similar optic, and again comes out with this wonderful line, that reality of law means that there are risks and dangers involved both in engaging in the dominant discourse and in not engaging in it, because when you don't engage you lose the good bits, when you do engage you get the bad bits. But if you're a powerless group, you know, that's you're always between a devil and a hard place, but this is a particular legal version of the devil and a hard place. Okay, so if that was my idea of what I was thinking was probably perhaps worth hypothesizing was going on with this problematic, I needed to find a way to try to investigate that. It's a bit ambitious, I appreciate, but the research design had to try to grapple with that. So I said the first thing of already using what exists and really, really delving and trying to get out the learning that already exists, often developed in real silos. So just the act of bringing it together, you can get something out. But very importantly, in terms of trying to understand this phenomenon, was just bringing everything in that might be relevant. This very much speaks to Anya's work, and so it's not enough. You can't focus on the law on the books. I mean, that's clearly bonkers. You can't focus on the law and the courts only. You can't just focus on what people are saying about these things and how they experience them, on what politicians and policy actors and academics say about them, or what the press says about them, or what people feel about them. Or you have to try and get the whole lot, because the whole thing is law and law and legal process. That's its interaction with society, and it just creeps in so many places, and Thompson could also help me with that. That's the second quote above. The rules and categories of law penetrate every level of society, and the idea of ideology as important, the ideology and the discussion that surrounds it. So, because often people think, one thing that I also repeatedly heard, including in interviews, was people conceptualizing that if people get the law wrong, that's nothing to do with the law. That's not a legal impact. So they would say, oh, this is how as an organisation we react to this. I know they've got that wrong, so that's not really what you're asking about, they would say to me. Whereas getting the law completely around your neck and wrong is a legal impact. It's just as much dancing around and playing with and reacting to and living with law as, you know, if you're as nerdy and ridiculous as me and know far too much about the detail of the rules. So trying to find a way to get more of a fully rounded picture. And I am very much a nerdy lawyer. I'm particularly a nerdy case lawyer. What I know about this stuff is just really the sign of a wasted life, but there we are. I do love it, and I fall in love with it, and there's a sadness about it, because I genuinely enjoy it, and I know it's all nonsense, really. There we go. So I am a doctrinal lawyer, and I feel sympathy for and empathy with others. But okay, I thought, given that there's so much talk about all this adjudication and all these rights and all, you know, so much in the press, I thought I want to get in there and try in a different way to understand what is going on with the adjudication that ends up in front of the courts. You know, everyone's so keen on it, and you know, there's so much attention to it. I wanted to really immerse myself in the actual judgments of these decisions. So, and absolutely. Funny enough, advised by Roger Cottrell, I went to him and at the beginning of this project and was talking about how do I do what I want to do, and he said, go away and read Carl Llewellyn, and particularly read, and also read William Twining's biography of him. So sent me back to the, to long time ago in America to find someone who really engaged, tried to qualitatively analyse a body of case law from a sociological, not an internal legal perspective. I know Joanne's done a lot in this area with her examination of adjudication, and there's clearly strands in feminist analysis which very much speak to this this side of the work, including the Feminist Judgments Project. In some ways it's the opposite, it's the other side of that. Okay, so The Common Law World is the Llewellyn book, which was innovated in this kind of work. But it's so interesting that it has not particularly been taken up by private lawyers worldwide, that kind of approach. Although one hears more, I now of course hear of people who are, Llewellyn types and using that kind of approach. I'm sure I'm sure there are many more than I hear of, but I'm interested that it seems that to me there's a bit of a revival there. So I undertook qualitative analysis of what I'm calling authoritative judgments about behavioural conflict in the UK from 1995 to 2010. So I've got a data set from there. And then so this is the other way that I was trying to get a more rounded view, was through an interview study of senior managers and lawyers. So finding out what was in the adjudication, and then going to talk about the people about whom allegedly it is regulating. So how were they responding? What did they perceive as the responses that were happening? And lawyers are great people. They also triangulated between themselves because they have different distorted viewpoints on reality. Interestingly, but I'm not going to go on about this, but one of the sets of findings is about the very distorted viewpoint of lawyers, the closer they are to the system, and how little a lot of them had an understanding that their viewpoints were distorted. But of course they are, because they're very, very close to this bizarre, tiny little group. But they're not social scientists. We have not trained them to be social scientists. So some of them are just very, very clever people talk to me, describing the world of work that they saw through the case law as if it was authoritatively. They would say, oh, I can tell you what work is like, this is what it's like, and you just look at them and think. But they weren't being ironic, they truly believe what they saw in courtrooms or in their case law is the world. And then others were very, very sophisticated, those with the sociological sensibility. So there was this weird range of positions in that, epistemological positions in that regard. Okay, but it did help to put these two together with the existing evidence, I hope, enabled me to theorise more generally. Okay, so I'm going to say in the last bit, and I am definitely going to take a little bit longer than I hoped, but there we are, that's fine. I'm going to talk about what I did with the qualitative analysis of case law. So my question for this was simply, how does law about behavioural conflict at work operate through authoritative adjudication? So I mapped out the massive amount of relevant law there is. It's huge amounts of it. So I mapped it out in an internal legal analysis, but the real heart, that was just background. The real heart was getting hold of judgments. Now I chose to go for authoritative. I've had many sleepless nights wondering whether that was a mistake or not. It's too late. But I chose to go for because but it means that I've got to be clear, and Llewellyn was quite bad about this, about contextualising his set of cases. Twining, for example, is very critical of that, but I was, so any qualitative analysis of judgments has to try to contextualise the slice of adjudication it's doing. The positive case for going for authoritative adjudication is that in this field, it's the adjudication that is the law, that has normative effect. Employment tribunal decisions have no normative effect. They decide the case in front of them. That was my positive reason. However, of course, in the life of the law, for a lot of there's many more ET cases, and so I'll come back to it would be a different study about different things if ET cases were brought in. And there's a case for that different study. There also may be a case for having done them separately, partly for the comparison possibilities that arise from it. But so the positive case for doing this is this is the law that has normative effect. Okay, and it was not an internal legal analysis. I only needed to include the background law to hopefully help readers to understand issues when they came up. But what I read the judgments for was recurrent themes in the way that stories about behavioural conflict at work were presented to courts and retold by judges. And secondly, patterns in how that adjudicator determined the behaviour between colleagues, that's whether peers or hierarchically colleagues, how it was unlawful, and how they also then determined their position on requiring or guiding organisations to respond to poor conduct or to allegations of it. So factual stories, how judges in these higher court decisions determined how they went about deciding behaviour was lawful or not, and how they went about requiring or guiding organisations in their response both to the conduct and to allegations of it. I chose a long frame because I hope for obvious reasons that is the time over which there's this really exponential increase in individual rights, and it also, you can have a bit more confidence that one's picking up something real rather than imagining. I've already said why I went for higher court judges. Now the sampling stuff is really, really hard because I can't know how. I ended up with this sample from lots and lots of database searches and trying to get at this construct of behavioural conflict at work between colleagues and hierarchically, and using definitely the growth in the language of bullying to find a lot. But I ended up with about 300-ish, I should have written it down, decisions over the period, and took out, I ended up with an actual sample of about 145, where that I really did the full qualitative analysis of, because at least half just went on further examination, ended up not being sufficiently fitting my framing of the kind of conflict I wanted to look at. But of course the tricky thing is we've gone from a vast number of problems at work to a very small number where there ends up being litigation, to an even smaller number that go up the court hierarchy. So this group here, in a way, the idea of representativeness doesn't really work because by definition they're outliers, they're weird. They're the ones where people fought on, there was enough money to fight on, there were issues to fight on. But even that, even just saying that and noticing that immediately brings centre stage how far the experience of judges, lawyers, and the whole adjudication system just is an outlier. So, actually, Lydia asked me to talk about my outliers. In a way, this is a study of outliers. When you study adjudication in courts, you're studying outliers. And I agonised about trying to understand this representativeness issue. So they are representative in the sense that they're all weird. And if you get to that level of adjudication, you're an outlier. So then I think it's okay to say, even if you don't know and you can't know the relationship between your sample and all the weird adjudication there is out there, you can feel confident you've got a critical mass, and that a critical mass is enough to give you a view into that. I could only know if I went. Actually, I can't ever know the answer to whether it's truly representative, because I can't do it again. I'd have to go to another country, and then it would be another country, and that would be different. So anyway, so these framing issues are hard with this stuff and take real rigor and thought and real. And by the way, I'm not saying I got it right. So that engaging with that methodological asset, I think, is one of the things I found the hardest. But one thing that I'm kind of happy about now is that, given the triangulation with the interview study and the cases, one thing it meant is that when managers and senior lawyers told me stuff about the law which is clearly wrong, because I knew it was wrong, both because it was doctrinally wrong, didn't fit what the adjudication said, and one of the things they went on and on and on about is law being obsessed with procedure in a really ridiculous, and I'm paraphrasing it, and I am being recorded, but they talked a lot about, they very much emphasised the proceduralism of law in this area, and that's what they felt as a legal influence, and lots of issues and problems about it. That did not come out from this study in any way like the way they described it to me. So that's an example. But they would say to me, some of them would say to me, but that's not really, that some of them who knew that the law didn't really require what their colleagues were telling them it required, that's when people would say, this isn't really a legal effect, is it? But it is a legal effect, just as much as if everything fit seamlessly together. But what that creates an opportunity. So one question is this perception about proceduralism, is it about ET decision making? So that would be a research question, or is it just a total mismatch? So where's the mismatch, I guess, raises the question. And then so that would be an interesting way of testing where there was a disjuncture in the data. But the other thing is, looking at ET judgments might be great, because they're different kinds of judges. The judges we get in higher courts are a different group of judges, so the influences on them, and this I think spoke to what Lydia was saying, would be you'd be able to do some interesting comparisons. I'm going to need to stop shortly. Okay, so but then what did I'll say a little bit about the findings, and then I'll say a little bit about my conclusions about how it relates to the themes of what we're talking about, although I've already touched on that. So in terms of the facts that came out, there were two major things that I found, which was just these many, many versions of complexity in the facts. Came out in all sorts of ways. One of the ways it came out in was a lot of ambiguity, including from claimants, about the role of their group identity in what had happened to them. So kind of messy, unclear, contestation, and worry and anxiety and ambiguity in people themselves. Not anything like this idea of people playing race cards or gender cards or any other kind of cards, but more a kind of worried reflection about what was really going on. And on some of my most heartbreaking interview data was from quite a few people who came to me and said the stuff about litigation being devastating. One of the things that most struck me is this is barristers coming out to me and saying, you know, it's devastating even if you win, and even if you win big. And the reason they had hypothesized that it was devastating was that they said you can fight your way through believing, for example, you've been harassed because of your race or your gender, and you can fight and fight and fight, but then when someone tells you, yes, you really, really have been, there's a heartbreak. Because somewhere in there, the whole way through, you remained attached to the idea that someone might turn around and say, no, it's just you, you're just a pain in the neck, you're not part of some massive structure which is oppressing you. So and when they first said that to me, I nearly fell off my seat because I couldn't understand it. And then I thought about it and it made sense. And it fits with a lot of data about how people respond to problems, particularly women facing sexual harassment, and how they'll do all sorts of things to neutralize it, to make it okay, to hang on to their loyalty, their attachment, their sense of belonging. They'll bend over backwards to try, which in a way is the ultimate proof of how far they're caught in an oppressive structure. So anyway, that but that kind of complexity went very deep. The other one that I guess is maybe interesting to quickly mention is some litigation that had just gone totally bananas, where everybody was being harmed, but only a very small proportion, but some truly terrible stories of litigation just getting totally lost. And yet but that litigation, I would hypothesize, captures the imagination of the press, of managers, of organisations, so I suspect that's one of the reasons why you get away. You don't focus on the iceberg and people trying to get things solved and often not managing. You focus on the very, very unusual situations, and in particular the ones where everything goes horribly wrong for everybody and everyone emerges having lost something. Okay, the other thing interestingly about the facts was this amazing judicial conscientiousness, and my other area is judicial diversity. I'm not, so I'm highly skeptical about judges and adjudication and how identity influences them, so this was a shock for me, that there was this really amazing conscientiousness about facts, without getting really down and dirty about the facts, in extraordinary detail and intention and specificity. Of course, they're a very particular group doing that, but it raises some really interesting research questions, which I could talk about later. Okay, then in terms of law, there are two very big patterns. One is that there's exponential increase in individual rights of all sorts and different types, leading to real arbitrariness in the outcomes. Because someone who goes through a behavioural problem at work doesn't know that they can sue in harassment or tort or contract or unfair dismissal or protection from harassment act. They're just having a behavioural problem at work. So you get this insane jurisdictional variety, and it leads to arbitrariness. So I had fun matching fact situations, which were very similar and totally different legal treatments because of vagaries and how this stuff ended up in before the court. And then the one that also did my head in, to put it technically, is the one about if the judges were allowed to get to the actual issue about the conflict, whatever it was about behaviourally, there was this extraordinary consistency and accessibility in the way they set about analysing it, asking very similar questions. Basically, is this behaviour okay or not? and is the employer's response okay or not? And it didn't matter whether it was a sexual harassment framing or a contract framing or a tort framing. Once they're allowed to get to the actual issue, there was this weird decision type approach, consistency. I'm not saying the outcomes were necessarily consistent, but the way of thinking was weirdly consistent. It was like, I can't know if the jurisdiction made absolutely no difference. The outcome, I suspect it very often didn't, but that's untestable. But the decision-making approach was just weirdly consistent. So as if all this variation is absolutely pointless. And indeed, yeah, so it's achieving something else. It's not achieving, it's about something else if it's not resulting in a fine-grained set of different approaches. And I could say more about they had repeated tropes that came up again and again and again that then led them to the decision, whether it was about the behaviour or the response. And that's where Lydia also asked me about outliers. On that, I found no outliers. It was bizarre. It was just so repeated. There was like one hint somewhere of a and it didn't necessarily, every pattern didn't necessarily count in every case, but were very strong themes going through. Okay, I've put something in about my overall findings, and I'll leave you to have a look at that. But in terms of gender rules, I think one of the things that talking today has made me think about is that the way I did this, and clearly there's a lot that's overlapping with a feminist approach, was very much about trying, in relation to this case law analysis, to trace the journey from adjudication to the societal impacts of law. And it felt to me this morning that quite a lot of our conversation was about feminism and feminist inspired methodologies, trying to find ways to go along that journey. In this study, individualism and the battle over individualism is, for me, the ideological battle that explains a lot of what is happening, and this interaction between individualism and individualization. But the normative ideological site for contestation is about the growth of individualism and a particular version of individualism and the struggle over that, and how individualization through law is supporting that on a particular version. But of course, in Whigs and Hunters, it was about ideas of property. For Crenshaw, in her study, it was about ideas of racism. Of course, I can think of many ways where one might have a similar study where the crucial ideological element would be patriarchy and sexism. By the way, I feel really, really awkward talking about my ideological construct in the company of my intellectual heroes. But anyway, I just have to say that because I'm a woman, so I can't stop myself being self-deprecating and saying I see it differently. Anyway, okay. And then the other thing that I think really is highlighted for me is this question of different ways of finding out and interrogating the impact of who judges are, the way they adjudicate, and the influences on them when they do. I think there's real rich picking. There's some hypotheses in here to study, but I think there's also rich pickings for ways of trying to crack open the influences on judges, which the Feminist Judgments Project is a wonderful methodology for doing. I guess this might have some ideas for going through instead of rewriting sources, going through the sources. But anyway, I'm sure you have views on that. Okay, I've spoken for longer than I wanted to, but hopefully we still have some time for discussion.